Good afternoon, ladies and gentlemen. I trust you guys are well. So you're welcome to the criminal law class for today. I will hold on for another 3 or 4 minutes to enable latecomers to join. And then I'll be back around 6 minutes after the hour. Hopefully you have listened to the lectures. You are ready with your questions. Thank you. I'll be back shortly. Okay, ladies and gentlemen, good afternoon once again. I believe we can start now. I seem to notice that the class attendance seems to have gone down gradually. Is it because the Christmas is coming that attendance is going down? attendance should not go down because Christmas is coming. And in any case, you people are supposed to be at home. So the more reason that you should even attend all classes, even if it is a day to Christmas. So I want to encourage you, don't relax. Christmas is coming, but make sure you attend your lectures and make sure you are preparing for the exam. Because like I said, in criminal law, when we return in the new year, we are going to have a test. So let nobody think that, it's a time to relax. I encourage you to work hard. And I can assure you that if you work very hard, you will have a good result to show for it. So we want to start. I've sent to you the lecture on conspiracy and parties. We have looked at attempt. Attempt is one of the inchoate offenses under the criminal law. We have also looked at, okay, let me enable one person to unmute so that I'll be sure that you guys can hear me. Pelumi, please unmute and confirm that you can hear me. Adelaja Pelumi.
I can hear you, sir.
Okay, so mute yourself back. All right, so we've had the lecture and the discussion on the offense of attempt. Today, we are looking at the offense of conspiracy and also parties to an offense up to the point that the video stopped. So we're going to start with the offense of conspiracy. So if you have your questions on the offense of conspiracy, please, this is the time to ask it so that we can respond, and then that will give us opportunity to make clarifications so that you can better understand the topic. So if you have questions, so we'll start with conspiracy. We'll take that for about 30 minutes or thereabout, and then we'll go to parties to an offense. So if you have a question on conspiracy, you can indicate by raising your hand digitally, and I will recognize you and enable you to unmute, and then you can ask your question. So where are the hands, ladies and gentlemen, distinguished students? Raise your hand. Why are you typing the question? Are you afraid for us to hear your voice? You don't want us to hear your voice? Iyanoluapo, please, you have been enabled to unmute.
Hi, sir. Good afternoon, sir.
Good
Sir, can you hear
afternoon.
me?
Loud and
Right.
clear.
Okay. So, I'm not sure if this is a question. I'm not sure if okay, let me just ask the question. From the video, I learned that a husband and wife, they cannot be charged for conspiracy because in common law they see husband and wife as one. So in a case where a husband and wife they conspire to, I saw this in a past question where both husband and wife they conspire to rape their housemaid, what would be their criminal liability?
Well, even if you cannot charge them for conspiracy, you can charge them for the main offense. You know, conspiracy is just one offense. If you cannot charge them for conspiracy because they are claiming spousal immunity under the common law, you can charge them for the main offense. And the punishment for the main offense is more than the conspiracy. Okay? So provided that the event occurred in a part of southern Nigeria that still applies the provisions of the criminal code, then you can't charge them for conspiracy. But you can charge them for the main offense, which is more, which attracts even greater punishment. So it's not a problem that they can claim spousal immunity. They can claim spousal immunity, but they cannot claim immunity from the substantive offense. That's the answer to that. All right, let me enable others to unmute. Yeah, Mr. Nwogba Samuel, I officially recognize you as one of the most diligent students asking questions in this class. So anytime you're around, come to my office. I will give you a copy of my book on plea bargaining. I will autograph a complimentary copy of my book on plea bargaining to you. Okay? So that's the reward for being a very diligent student. So you can unmute.
Okay, sir. Good afternoon, sir. Thank you so much.
Okay.
I really
So did you hear
appreciate
that? Anytime you are in school, come around to my office. I will
All right, sir.
autograph a copy of my book on plea bargaining to you.
All right, sir. Thank you so
And I
much.
believe you have a copy. Do you have a copy of my book on criminal law?
Yes, sir.
Okay, I will have given you that as well if you don't have. Okay, go ahead.
Okay, so I have about 3 questions on the conspiracy.
Yeah.
So the first one is, I want to know, would it be considered a conspiracy if 2 fellows or 2 persons negligently or innocently agree to carry out an act which they never know, constitutes a criminal offense before they carried out the act? I want to know if they acted innocently.
But you need to know also that there is a general law that ignorance of the law is not an excuse. And I'm sure you know that. So
Yes,
if they agree to carry, if they agree to do something which they did not know is an offense, that cannot be a defense. Because ignorance of the law is not a defense to criminal liability. So that's a simple and straightforward answer to that.
Okay, sir.
Second question.
I want to know, is it right to say that the mere agreement to commit an offense qualifies as an actus reus of that particular offense with respect to conspiracy?
Say that again.
So is it right to say that the mere agreement to commit an offense qualifies as an actus reus, with respect to the crime of conspiracy?
Well, I think the answer, yes, you can say that. You can say that because the agreement is the doing part of conspiracy. That's what constitutes the act that the law criminalizes, where the parties agree together to commit an offense or agree together to to do something that is unlawful. That agreement is the offense. Like we said, the law does not even require them to go ahead and attempt to carry out what they have agreed. Once we can have an evidence that there is an agreement to commit an offense or to do something that is unlawful, then the offense is complete. So the agreement is like kind of the actus reus. Yeah. Next question.
Thank you, sir. Thank you. So the next question is, would conduct or silence amount to conspiracy? In that, let's say that maybe someone is in a situation or in a scene whereby 2 or 3 fellows, conspire or agree to carry out an act or about to carry out an act, but one of the parties didn't utter a word or just feign ignorance, whereas he was there when the offense actually took place. So
okay,
if he's been
I
arrested,
understand. Yes, I understand what you're trying to say. There's a scenario that I will give that captures that. So now, assuming that our law annex, and I think I've given this example in the criminal law class before. Assume that in our criminal law class, some students from BISADMIN used to come around to hold their lectures there. And we have been telling them that, look, this law annex It's only for Faculty of Law. We don't want to share with anybody. And they keep insisting, what do you mean? Are we not all students of UNILAG? We all paid to be students in this place and so on and so forth. So you guys in your criminal law class have made up your mind that the next time they come to the class, you are going to beat them up. They are going to beat them up if you ask them to leave and they don't leave. Okay, so your agreement to beat them up is a conspiracy. Now let's assume that unknown to me that you guys have made that arrangement. I walked into the criminal law class and I said, who are these people, you know, all over the place? I mean, of course, it was easy for me to know them that they are not law students because they were wearing multicolored clothes. And the class responded in row. There are people from this and me. We have been asking them to leave. And we are going to beat them now if they don't leave. And then, you know, as the person in authority, I could have used my authority to say, okay, everybody calm down. You guys from this admin, this is not your faculty. Can you please take your leave? Law students, hold on. I will get them out of the class. That's what you expect that a person in authority will have done. So if I then, knowing that you guys have made up your mind to beat them and, you know, knock them out of the class, and I just keep quiet and I just watch as events unfold. Now, I have no agreement with you to commit the offense. Okay? My silence there can constitute either a procurement or which is under Section 7D, which is encouraging someone to commit an offense. So my silence there, knowing that you are about to commit a crime, may constitute me as a party to that offense, but not as a conspirator, because there was no time, there was a meeting of mind between me and your class to engage in that criminal enterprise. But because on the spur of the moment, I did not intervene when I ought to have intervened, my conduct can be taken as either enabling the commission of the offense, which, as we will see later, will be Section 7B, or Section 7D, you know, encouraging the commission of the offense, but certainly not conspiracy. I hope that's what you had in mind. Is something similar? Yeah, is yes. Is something similar to that you had in mind, right?
Yes, sir.
Okay, thank you. Any other question?
Yeah, still the last one on conspiracy.
Okay.
I want to know, are there no defenses that lie for the offense of conspiracy? No defenses at all?
Well, there's no defense specifically tailored towards conspiracy. I can't readily think of one now. Because you agreed with somebody to commit an offense. That is what conspiracy is. Unless your agreement, well, maybe if your agreement is a product of a mental disease or natural mental infirmity, which made it impossible for you to know that you ought not to do the act or make the omission, or which made it impossible for you to know that it is wrong to agree with another to commit an offense, then the defense of insanity can avail you. Okay, so it's possible to have some form of defense that may avail in that circumstance. All right, thank you, Samuel. So let's go to other people. Mute your device. Eyo Banita. Eyo Banita Oluwa Konyisola. Or mute.
I guess so, sir.
How are you doing?
I'm fine, sir. So, sir, my question is that with regards to the party in a conspiracy, you said that there are certain people which you enter an agreement with that may not lead to a conspiracy, such as probably like the sole director of a company. But I didn't quite understand that point, sir, because does it mean that because the company is a wide establishment, then there can't be a conspiracy between the sole director and that company?
You see, in the criminal law, a company is a corporation, a company is a legal entity, it's a legal persona. And in the criminal law, because it's a legal entity, for offenses involving mens rea, a legal entity cannot have mental element. So the law found a way around that problem by ascribing to the company the mental element of its directors, or people that has been said to constitute the directing mind and will of the company. So in this instance, it is the director that is a human element behind the company. So if you charge a company for an offense involving mens rea, you necessarily have to find a human person who is a director or another principal officer of the company to whom you can ascribe the mental element. So the mental element of that human person will then be ascribed to the company, and then the company can be held liable for offenses involving mens rea. Initially, it was not possible for companies or corporations to be held liable for offenses involving mens rea. But the law found, the common law courts are very creative. They found a way around it through the doctrine of the alter ego doctrine. Through the alter ego doctrine, by ascribing the mental element of a principal officer of the company to the company, and then on the basis of that, be able to hold the company liable. So if the company and the director are one and the same person, okay, and the director, it is the mental element of the director that is ascribed to the company. So that then means that you cannot charge the company and the director together for conspiracy. Okay? You cannot charge the director and the company for conspiracy. You cannot. But if the company now enters, the company acting through the director enters into an agreement with another human being or with another company, with another company's director to carry out an act that constitutes an offense, then you have two different human entities involved. And then you also have two corporate entities involved. So the two of them, the two companies can be charged together for conspiracy. And the mental element of the agreement and the agreement there will be ascribed to them. So that is why a company is an entity, but it can only function through its human agent. And because the mental element of the human agent is ascribed to the company, that is why you cannot charge a director, a sole director of a company with the company together for the offense of conspiracy between them alone. It must involve another third party. Peace. On mute. Benita, you can lower your hands now. Good afternoon.
So when I was listening to your video on conspiracy, you gave ingredients. So on the third one, you said where one or more of the parties involved in an alleged in conspiracy merely enters into the agreement for the purpose of procuring incriminating evidence against the defendant who instigated the conspiracy, there is no conspiracy. That's in State versus Otu. So my question is now, but the law does not allow for illegal way of carrying out a legal task. How do we reconcile, this with this third ingredient for conspiracy, sir?
No, you see, the case of, in Oti's case, somebody wanted to assassinate a witness. He now recruited other people to enable him to carry out his criminal enterprise. But those other people now went and informed the police. And the police now told them, play along with him. And they played along with him, and the police arrested him. But the police ought not to have charged the other people with conspiracy because they've already informed the lawful authorities what they were trying to do. So the police charged all of them with conspiracy, and the court said, look, these other guys are not ad idem with him because they only played along. They were not truly in agreement with him to carry out their lawful purpose. If they were truly in agreement with him, they wouldn't they wouldn't have reported the matter to the police. Okay, they will just have gone ahead and assassinate the witness. So it is in that context that decision is relevant. You cannot isolate it and then maybe now try to twist, you know, as it were, to twist the meaning. So that's why the point is where one or more of the parties involved in an alleged conspiracy merely entered into the agreement for the purpose of procuring incriminating evidence against the defendant who instigated the conspiracy. There is no true conspiracy between them because they're only playing along with him. They don't truly agree with him. If they truly agree with him, they will have resorted to, you know, killing the person that he wanted to assassinate. All right. Elizabeth Praise Ajama on mute.
Okay, good afternoon, sir.
Yeah, how you doing, Elizabeth?
I'm fine, sir. Thank you. Please, my question on conspiracies. What of a situation whereby someone has already agreed, like the minds have been made already to actually conspire with the other party, but probably before the whole action takes place, he actually changes his mind, although the change of mind is not communicated to the other party. Can he still be charged for conspiracy?
Whether he communicates his change of mind to the other party or not, and the other party goes ahead to commit the offense or not, the liability for conspiracy crystallizes once there is an evidence of an agreement between the parties. Let me give you a scenario to illustrate. Now, assume that I send you an email and I said, look, this is our female, first female vice chancellor in the university. I don't like the way she's, I believe that she's oppressing all of us, those of us who are not, that are male lecturers. And I write a letter to you and I ask you, please, come and help me to, you know, waylay her on the road and beat her up. And then you send an email back to me that, yes, even you as a student, you have grievances against her. They increase the I mean, what do they call it? The utility fee. Of course, the university increased the utility fee to take account of increase in electricity, but you are not happy, and you responded to my email that, yes, I agree with you, sir. Let's work together to deal with that. Now, at that moment, at the moment you agreed and you sent me an email agreeing with me to join me in that criminal endeavor, we have committed the offense of conspiracy to commit the offense of assault. So even if later in the day, or maybe some days later, we now met and we said, look, this is our idea of trying to beat up the VC is not a good idea. Because, I mean, she was only doing what she felt was right for the university in the circumstances. And we said, okay, let's just leave her and let's go about our ways. The offense is already committed. The moment you agreed and you sent that email, the offense is complete. That's why in the lecture, if you listen to it carefully, it was stated that the offense of conspiracy is complete the moment an agreement is reached. Once there is an agreement, the offense of conspiracy is concluded. So whether the party goes ahead to commit the offense or whether the person is now right to say, I no longer commit the offense, it does not matter. The offense is complete the moment the parties agree. Because at that point, the offense crystallizes. Yes. It is not like attempt. You know in attempt, the person who wants to commit the offense of attempt has an intention of committing the offense. But it does not stop at the level of his intention. He now begins to, make preparation. He begins to take steps, adapted to the fulfillment of his purpose. Until the point that we can say that he has reached an attempt. In conspiracy, all those extra steps are not necessary. Once there is an agreement, the offense is complete.
Okay, sir. So,
Or do you have another question? You can unmute again. You can unmute, Praise. Do you have another question?
Yes, I do, sir. So what I'm saying
yeah,
is that
go ahead.
conspiracy is just merely intention. Why whatever the
No,
action
it's not
actually
intention. No, it's not intention. It's not just intention alone. If you intend in your mind to commit an offense, like I said now, you don't like our VC. You want to commit an offense against her. The other person does not like her too. He is intending in his mind to commit an offense against her. Now, there's no problem with that. But the moment the two of you, so it's not just a question of in intention. The moment the two of you now agree, you form an agreement, and there is evidence of that agreement. If it is in a phone conversation, we are able to intercept the phone conversation. Unknown to you, your phone was being monitored. And we have a recording where the two of you agree to commit the offense. That's it. That's it. Okay? All right.
Okay, sir. Sorry. Hello, sir.
Do you still have another question?
Yes, sir.
Oh, yeah, quickly. Go ahead. That's
Okay,
the last
thank you.
one. So that others
Yes,
too,
sir.
because I can see a lot of hands raised up.
Yes, sir. Scenario, what if there are no evidences? Like probably the other
And
parties actually.
if there's no evidence, then there's no offense. There have to be
No.
evidence.
So like they
You know,
cannot
that's
be
why we
any
said, that's why we say that usually the evidence of conspiracy is usually from inference or from a combination of circumstantial factors. Of course, there have been instances where law enforcement authorities intercepted telephone communications between criminals or intercepted email conversations between terrorists. And then, based on that, they'll be able to arrange them for conspiracy to carry out terrorist activities. But if there's no evidence, then there's no evidence. If we meet and we had an oral agreement, unless one of us now confesses, okay? If the two of us meet and we orally agree that we are going to commit an offense, and then you somehow the police arrested you and said, the way you are looking, we suspect that you are planning to commit an offense. I said, yes, you are true, you are correct, sir. Although I've since repented. I had planned, I'd agreed with Mr. A to commit this particular offense, but I later changed my mind. That your statement alone is enough to get you convicted for that conspiracy. Whereas if your statement of confession that you planned a conspiracy with me it cannot be used as evidence against me. If they come to me and they say, yes, Professor Bello, you conspired with your student to commit an offense against the vice chancellor, I say, me, I never did such thing. I did not, even though I agree with you already. I said, no, I never did. And there's no video evidence, there's no recording. That is the end of the case. The police may not succeed against me. But based on the fact that you confess, they can succeed against you. But if there's no evidence, then there's nothing anybody can do. We agreed orally, and then we all went away, and nobody has any evidence of our oral agreement, then there's no conspiracy. All right, Praise. So mute your device. Let me call Adela Japelumi. Adela Japelumi, please unmute and quickly ask your question so that we can. There are so many hands so that we can go through as many questions as possible.
Thank you, sir. So I just wanted to ask if the defense of compulsion is available in a scenario where maybe someone was forced to agree, maybe they were under duress, and then in that sense they had to agree. The
defense of compulsion can apply to any offense, provided it is within the limit of the scope. You see, those general defenses that we looked at, that's why we call them general defenses to criminal liability. If those defenses fit the context of any particular offense, then they're applicable. Do you understand?
Yes, sir.
That's why we call them general defenses to criminal liability. Once you can successfully establish the ingredients of the offense in relation to of the defense, in relation to any offense, then it's available. All right. Mute yourself and bring down your hand. Praise, bring down your hand so that we know. Adelaja, you to bring down your hand. Okay, let me call this person. Osarere Joy. Unmute and ask your question. Osarere Joy. Osarere Joy. Unmute now. Okay, let me try again and unmute you. Enable you to unmute. Yes, Osarere Joy.
Okay, good afternoon, sir.
How are you doing, Osarere?
Fine, thank you, sir. So my question on conspiracy is a bit interwoven with the law of attempt, and it's on impossibility in conspiracy. So,
yes.
So you know that there is no clear provision or guide on the effect of impossibility on that conspiracy,
yes.
like yes. The way it's attempt.
It's done in attempt, yes.
Okay, so and so you know that in the scenario you gave us, you said that under attempt that if a person tries to assassinate the president, but unknown to him, the president has already died.
The president was not in the car. Yes.
No, we said on there was a scenario you gave that unknown to the person, the president had already died the previous night. So, yeah. But they came the next day to effect their purpose. So you said that kind of person will still be liable for attempt. So attempt to murder the president, even though he was already dead.
Yes.
But so does that mean that if there were, for instance, two that conspired to murder the president, and does that mean that they will then be convicted of rather attempts to murder the president, but not conspiracy to murder the president?
Yes, that's a very good question, because like I said, the code is not very clear on the question of impossibility in conspiracy. The code is not very clear. It is not very clear. Unlike in the case of attempt, where it sets out the rules very clearly and mention all the immaterialities. So if the offense is legally impossible, now in this case, if the president is already dead, then I don't see how there can be a conspiracy to kill him. I don't see how there can be a conspiracy to kill him if the president is already dead. But of course, in the example of the attempt, that one is different. It's not just a case of legal impossibility, because the president was not in the car. They did not know that the president had died. They were just taking the vehicle to the presidential villa, for instance, pending when announcement will be made that the vice president maybe is now the president, and he will now ride away from the presidential villa in the president's car, because now he's the president. And the assassin now shot at the empty president's car. Now, of course, the president was not there, and so he couldn't have killed the president. Now, in that scenario, it was factually impossible to kill the president, but he will be liable for attempt. He will be liable for attempt. So that is the way. So the conspiracy on is a bit, one is not sure how the court would apply it, because for instance, if you look at the case of just a minute, if you look at the case of Otegeri, an IGP. Onyemaechi held that there was no conspiracy because what the accused agreed to do did not disclose any offense. Whereas in Majekodunmi and the court held that a person may be convicted of conspiracy to commit a crime, of which he could not, if he stood alone, be convicted. Now, what happened in Majekodunmi's case was that somebody conspired with an employee of the Post and Telecommunications to steal a postal matter. Ordinarily, it is only employees of Post and Telecommunications that can steal a postal matter because they are the ones usually in custody of a postal matter. So there was no way you can charge somebody who is not an employee of Post and Telecommunications with attempting to steal a postal matter. Okay? But in this case, the court convicted a person of conspiracy to commit a crime of which he could not, if he stood alone, be convicted. Somebody conspired with a postal officer to steal a postal matter. Ordinarily, it is legally impossible for him to be convicted of stealing a postal matter because he's not a postal employee. Maybe he could have been convicted under another offense of stealing a letter, because the offense of stealing a postal matter is specially created for post office employees because they are in a fiduciary relationship with their employers. They are employed to safeguard, to keep and deliver postal matters, letter, telegrams, registered letter, and so on and so forth. But another citizen may be charged with stealing a letter because that letter will belong to someone. But he cannot be charged with stealing a postal matter because the offense of stealing a postal matter is only an offense for which employees of the Post and Telecommunications could be held liable. But the court held that, well, irrespective of the fact that he could not be convicted if he stood alone of that offense, he can be convicted of conspiring with another person to convict him. So, you know, like I said, the law is not very clear on that point. The law is not very clear on that point. Okay, so let me go to another person. So you can mute and bring down your hand. Let me take Tayo Adekunle. Tayo Adekunle, please unmute and ask your question. Tayo Adekunle, unmute and ask your question. Tayo Adekunle, unmute. Unmute. You have to unmute.
Good afternoon, sir.
Yeah, afternoon.
Yes, sir. Sorry, my question is on conspiracy, sir, particularly with respect to the parties.
Yes.
So in your text, you cited a case of Aaron Phillips to the effect that the other party need not be identified. The other party to the conspiracy need not be identified.
Yes.
So I'm not trying to resolve the seeming controversy in if parties are parts of the elements or the ingredients of the offense.
Yes.
On one hand, the judicial authority is saying that the party needs not be identified.
Okay.
How do we
let me give you the kind of scenario that can result from. Now, let's assume that they found an email in your email box asking you and promising you that if you are able to take an explosive to detonate at the National Assembly, you'll be paid the sum of $5,000. And they found another email in your mailbox replying to that email, agreeing to the deal that, oh yes, I hate all those people at the National Assembly. Let's go and bomb all of them out. Now, the authorities may not be able to locate the person who sent that email to you because the person may have encrypted the email that, although the email landed in your mailbox, but it could not be traced. The person might have used a fake email address that cannot be traced. But what is important is that there is evidence against you that you agreed with an unknown person to carry out an act that constitutes an offense. So that alone entitles the authorities to charge you to court and you may be convicted, even though the person with whom you allegedly entered into an agreement to carry out that conspiracy is unknown and cannot even be found. Is even nameless. Okay, so that's the circumstance in which that may arise. Good success, Udo. You can unmute. Good success, Udo. You can unmute.
Okay, good afternoon, sir.
How are you doing?
I'm fine, thank you, sir. So my question is this: what if somebody that wanted to, like a conspirator, changes his mind, and he then, in a bid to thwart the conspiracy, reports to authorities? So he's not confessing when he's caught, he just goes willingly and reports.
Okay, that's a very good question. Now you see, again, we must stick to principles. The principle of the law is conspiracy is complete once the agreement is reached. So he's still liable to be charged with the offense of conspiracy. Okay? Now, but the fact that he has come forward to confess, that may make the prosecuting authority to exercise their discretion in his favor not to prosecute him. When you finish your LLB and maybe you come back for a master's in our faculty and you do comparative criminal law, you will learn about prosecutorial discretion. The fact that an offense has been committed does not mean that the prosecution will prosecute the offender. They take a lot of factors into consideration in determining whether to prosecute or not. If the conspiracy relates to a minor offense, for instance, then they may choose not to prosecute. Even if it relates to a very serious offense, they may choose not to prosecute this person because the person is now repentant. They may rather choose to use him as a state witness against the other party with whom the alleged conspiracy was made. Okay, but if they disregarded all that and charged him to court, he will be convicted of conspiracy. But again, the court will take into consideration the fact that he had come forward, he had confessed, he had shown remorse to now reduce the punishment that the court will give him in the circumstances. So that is the way to respond to that. But on the point of principle, he has committed the offense of conspiracy and is liable to be convicted. Obafemi Grace Oluwa Funmi or something. You can unmute.
Good afternoon, sir.
Afternoon.
I'm sorry, my question is quite similar to the last question that
Try and raise
asked.
your voice a little bit.
This is my question. It's quite similar to
Yes.
the question I was just asked. But my question is in a hypothetical scenario whereby, for instance, a group of guys, they accost the girl and then their plan is to assault her, maybe just threaten or scare her or something. And then they now get to the site where the girl is, and the mastermind behind the assault now decides that he's going to take it a notch higher, and then he begins to sexually assault the lady in question. And then one of the guys pulls her from that, and then he goes to report the mastermind, and prior to that he was a conspirator. So if he goes to report to the authorities, will he still be liable for conspiracy?
Yes. Again, the moment they agree, don't forget the principle, the first principle, very, very important. Once there is an agreement to commit an offense, the offense of conspiracy is already completed. You need not do anything more. The mere evidence of an agreement to commit an offense constitutes conspiracy. Okay? Now, they don't need to take any step at all in pursuance of that agreement. It is when you are talking about attempt that you are now saying, what steps are they taking beyond the intention? No. In conspiracy, all that is not relevant. Now, their conspiracy was to go and assault the lady and just beat her up, but they didn't do that eventually. So they are not liable for the offense of assaulting the lady. But the mastermind now goes ahead to rape the lady. He alone is responsible for that offense, unless there's any one of them who aided in committing the offense. So if somebody now helped him to restrain the girl while he had his way, then that person will be liable for aiding the offense of rape. All right. Ogochukupo Naji. And then we will go over to, you can unmute, then we'll go over to parties.
Hello, sir. Good afternoon, sir.
Good afternoon, Gochuku.
Right. Sir, my question is, it's similar to something someone had asked before, but it's concerning the statement of law that other party of the conspiracy does not need to be identifiable before you can convict one person you have proof against. So, but someone earlier asked that, what if there is no proof, but what if there is no evidence, but it's only one person that confesses? But then
the person that confesses, hold on, the person that confesses under the laws of evidence, that confession is evidence against him alone. It's not evidence against the other party, unless that other party also confesses. So if two people engages in the conspiracy, one of them confesses to the conspiracy, on the basis of that, he alone can be convicted. And the other person does not confess to conspiracy, and there is no evidence against that other party, then he may escape conviction. The evidence of confession only proves the offense against the person who confessed. It does not prove confession against the other person, because he will say, no, I never said so. I never agree with you to do any offense.
Even though this other person is technically identifiable in this case, he's just denying it.
Yes, yes. Because you see, when persons are charged with an offense, if three people are charged with an offense, the evidence of the commission of the offense must be proven against each of the three offenders. If you are able to prove that only two of the three committed the offense, the third person will be discharged and acquitted.
Okay, sir. Right. Thank you.
Okay, so let's move over to parties to an offense. So we looked at parties to an offense, you know, and then we looked at section 7A, B, C, and D. And then we looked at what those provisions says, and so on and so forth. So the floor is open for questions on parties up to the point at which the video stopped. I will send you another video for the concluding part of the lecture on parties to an offense. But up to the point that the video stopped, you can ask your question by raising your hand, and you will be identified. There's no question on parties? Okay, work by Samuel. On mute.
Okay, sir. I have some questions.
Yeah, go ahead.
The first one is, I want to, in a situation whereby A procures B to QC within a timeline, you know, so if the timeline elapses and B goes on to QC, so would A be held liable? So in the absence of, you know,
A may still be held liable if he has not countermanded, if he has not specifically countermanded his instruction. He may still be held liable. He may still be held liable. What if the person will try to kill him during the relevant period and he could not kill him, and the opportunity came shortly after, and then he kills him? Unless he has countermanded his procuring. Any other question?
Yes, sir. So with respect to section 7, so I want to know, in a situation whereby one person falls within the categories of paragraph B, C, and D. So I want to know, would the weight of his punishment be more severe than when that person falls only within the category of perhaps maybe paragraph B?
Well, yes, that's a very good question. That's a very intelligent question. Now, if you fall within paragraph B C. That means you did something to enable the commission of the offense, or you provided an aid when the offense is being committed, or maybe in paragraph D, you are the one that is a mastermind. You procured others to commit the offense. So in law, I mean, in the principles of sentencing, the masterminds usually receive a greater amount of punishment than other levels of offender. Because the mastermind is the one that initiated, that orchestrated the commission of the offense. And in most cases, is the one that will recruit other members of the team. And because of that, under the rules of sentencing, the mastermind usually receives, if the punishment is 7 years, if the court sentences the other offenders to 3 years imprisonment, the court may send the mastermind to 6 years imprisonment out of the maximum of 7. Yes, the mastermind usually, receives higher punishment than other persons who participated in the commission of the crime. Any other question?
Yes, sir. I want to put a scenario. What happens to maybe a detective or a police officer who, at the course of investigating a crime, let me say human trafficking, so decides to join a group in disguise and ends up being raped and trafficked at the same time? So who would such officer bring an action against? Is it against the state that sends the officer to investigate the crime, or against the traffickers?
Well, that's not a question of criminal law. That's not a question of criminal law. You are just asking a general question. If you have asked the question, yeah, it's not a question of criminal law. Your question must relate to criminal law. Okay. On mute. Unless you still have another question. Okay.
Okay, sir. Sir, it's more of a clarification, sir, not a question. So, when you were teaching, sir, you said that a person's presence at the crime of a scene is not enough for him to be held to be a party to the offense, that he must have something that's aided the crime to be committed. But then, I think it was Faustina that asked this question at the beginning of the class, that and then you then explained that if the whole class is rowdy and all of that, and you, sir, you come into the class and you fail to do anything about the whole situation between the law, that you may be held liable as a party to the offense. Sir, why? Is it because you were in the position to stop it, or because does not?
Yes, because my presence there, if my presence and my silence can be taken as an encouragement to commit the offense, then I may be liable. Like I said, if I come to the class and I see that you are about engaging some other students in fisticuffs, you're about beating them up and throwing them out of the class because they are from beside me, they're not law students. As a person in authority, I'm supposed to intervene and say, no. You shouldn't do that. I'm here. I will tell them to go and they will go. But if I then keep quiet, then, and you have declared your intentions of what you want to do, which I know is unlawful. And as a person in authority, I kept quiet to use my authority to preserve law and order. My quietness, my silence, and my presence there can be taken as an encouragement to commit the offense. And I may be liable for that offense. I may be. So that's the reason.
Okay, understand.
Adebayo Rokib, you can unmute.
Okay, thank you, sir. Yeah. Good afternoon, sir.
Good afternoon.
Yeah, my question is, if any person who counsels or procures another person to commit the offense of murder, and the person gets to where he's about to commit the offense of murder, and he just goes ahead to rape the human before he commits the offense of murder. will I that procured or counseled the person to commit the offense of murder be held liable for all the offenses, or just
No.
for murder?
No, no. You can only be liable for offenses for which you have procured. You may also be liable for a lesser offense. For instance, if it did not succeed in killing the person that you procured him to go and kill, and the person survived, you may be liable for inflicting grievous bodily harm on him if you only injured him and miraculously the guy survived. But if you procured somebody to commit an offense and the person committed a completely different offense, then you are not liable. You are not liable. Unless
Okay,
unless that other offense is a lesser offense to the main offense. If it is a lesser offense, like I said now, you procure somebody to go and kill somebody, and the person went and cut him with a machete, and fortunately for the victim survives. You procured him to murder, but he had committed the offense of grievous bodily harm. You'll be liable for the grievous bodily harm because the grievous bodily harm is a lesser offense and is included within the more complex, serious offense of murder. All right.
Okay. Thank you, sir.
Goodness, Udo, on mute. Goodness,
Okay.
Udo.
Good. Okay, sir. My question, I'm a little bit confused, sir. What is the difference between an
About
accessory? Yeah, what's the difference between an accessory and somebody who aids or abets a crime?
an accessory. There are two types of accessory. There's an accessory before the fact and an accessory after the act. An accessory before the act is somebody who has done something to aid the commission of an offense. An accessory after the act is somebody who is aiding another person after he has committed an offense to escape. But there are two types of accessory liability under Section 7 of the Criminal Code. There's Section 7B that talks about doing something to enable another to commit an offense. Then there is the second one, Section 7C, that talks of aiding another to commit an offense. So the B part appears to cover an aid that is provided before the offense is committed for the purpose of enabling the commission of the offense. While the second aiding in Section 7C relates to aid offered at the time the offense is being committed. But both are accessories before the act, which constitutes an aid, to facilitate the commission of an offense. Joy, your hands are still up, or you have another question? You can unmute if you have another question. I've enabled you. Okay. Joy, is your hand still up? Do you still have another question? I've enabled you to unmute. If you don't have another question, then bring down your hand. Okay, so is there any other question? Okay, Samuel, unmute.
Okay, sir. Just for the purpose of more clarity, I want to know if a person can be charged with both, procuring an offense or counseling an offense and actually committing the offense.
Well,
both charges at the same time.
They will just be charged with the offense. That person will be charged with the offense. It is the evidence that will show whether he was the one that actually did it or whether he procured another to do it. It's not as if they will be charged separately. Okay. All right. Any other question? Okay. If there are no other questions, I want to encourage you to go back and listen to those videos carefully. And then also do additional readings on it. I mean, you have the ability to listen to them over and over and over. And, with all the illustrations, with all the explanations, and then do additional readings of your own. Okay? And then when we come back in January also, we're going to have opportunities to do tutorials where we'll look at some questions and then we'll go about, and then we'll explore how to answer problem question and how to answer essay question when you are confronted, with those kinds of questions in the criminal law. So if there are no other questions, then we'll end it there. So I encourage you to indicate your matric number in the chat box. I can still see 2 hands. Habib, do you still have any question? Or mute. Sorry, I said, yes, Habib. You can unmute if you have any question.
Hello, sir.
Yes.
Good afternoon, sir. Thank you for the class. My question is not on conspiracy or attempts. It's actually on attempts, and that's why I have to go to the end of the class to ask.
Okay.
So
yes.
in your
yes,
text, you gave an illustration of something that when someone has died, and when someone has died, the person and the defendant can be convicted of the offense of attempt again. So I want to ask that in a situation whereby someone has indeed died, and then the other person who wants to now commit an offense, now let's say shoots the person. There's this common thing among Nollywood movies, especially the Yoruba ones, where they come to the scene and say "Akutukutu Elono," that is to hell with you, and they just shoot again to just show that.
And the person is already dead.
The person is already dead. So in that instance,
we've said that somebody asked a question that's similar to that. If somebody is already dead and you shoot him, you have not committed any offense. He's already dead and you shoot him. Shooting his dead body. You have not committed any offense. But that is different from the scenario of the guy who wanted to assassinate the president. Okay? Because he thought the president was in the car. And he fired at the car. But the president was not in the car. That was a factual impossibility. He will be liable for the offense. You see, you also need to realize that the way the court will construe some of these matters, there is some measure of policy involved, policy consideration. The court will look at the policy. Somebody wants to kill somebody and fires a gun at the car, and the person is not there. Even if he does not kill that person, he could have killed the driver. He could have accidentally shot and killed the driver. So you cannot allow such a person to go completely scot-free. And in any case, the court will just apply the rule that it's a case of factual impossibility. But for somebody who's already dead completely and you shoot directly at him, and you shoot the dead body, I mean, I can't see how that can be an offense. I've answered something similar to that earlier. Karim Lawal. Oh, sorry, I said Karim Lawal. Rakib, do you still have a question? On mute.
Yes, sir. My second question is, if I encourage someone in a state where the criminal code applies to go and commit a crime in a particular state where the penal code applies, will I be held liable under the penal code or under the criminal code?
Well, the question you have asked is not a criminal law question. It's a criminal procedure question. The answer is, if you are in Lagos, just like the case against Wale Delefa Moroti, he lives in Lagos. The alleged defamatory matter was published in Ekiti. People were frowning that why should he be arrested in Lagos and taken to Ekiti? The course of action in defamation is where the thing is published. People read the book in Ekiti. So for that purpose, the offense is committed in Ekiti. Do you understand? Even though it's physically here. So it can be taken from here to Ekiti and charged to court in Ekiti. Okay, so if you are in a place and you commit an offense you do something that constitutes an offense in another part of Nigeria where another criminal code of a state or another penal code law of another northern state applies, you'll be tried in that place. And if you commit an offense in Lagos, you'll be tried in Lagos. So the rules have been designed in such a way that you will not be able to escape. It's either the law will allow you to be tried where you are or where the effect of your act results. So both ways, the offender is not going to escape anyway. All right. So I encourage you to read very well, work very hard during the holidays. As you eat chicken and turkey and all other things, make sure that you also know that when you come back in January, and hopefully when the school allows you to come back, then you will have a test. Or whenever you are allowed to come back, know that you are going to have a test. So put your details on the chat box. I don't think we are up to 300 today. I don't know why the class attendance has reduced from 300. I mean, we used to hit 300 and above 300, and then the thing will take the class, will take those coming into Zoom. But although, to my YouTube channel, nobody has been taken to my YouTube channel today because the class is not up to 300. So I hope you people are not playing with attending classes. It's very important to attend classes. We are taking attendance, and then, just make sure that you are up and doing. So thank you for attending the class. Go and continue to listen to your lectures. For those ones that are on video, the ones you've had physical, you've had other lectures on Zoom. Go and be reading very hard. Prepare for tests and exams. Before you know it, exams and tests are here. And I wish you all the best. Bye-bye. So I will hold on for another 2-3 minutes for you to indicate your chat. To indicate your attendance on the chat. Bye-bye. God bless.